So this is really common. This happens to so many workers, so many employees. They don't know their rights. We don't know our rights. We're not taught this as we're, going into the workforce at very, very young ages. We enter the workforce at 14 years old, and none of this is actually really taught to us until you actually go through a situation. You do your own research, you speak to different lawyers and people who are actually under the employment relations bracket or umbrella that can give you this real advice that is essentially non-accessible, or the information that is presented to us is very ambiguous, it's hard to understand, it's hard to read, and I'm telling you right now that is deliberate. So a common misconception is that you still need to be employed by the company to actually submit a workers' compensation claim. This is not true. So you do have up to 6 months, usually particularly in Queensland, to be able to still submit a claim. And usually this is based on the date that you have reported your injury, or you have it in written documentation when you've gone to your GP, for example. Because again, you wouldn't be submitting a workers' compensation claim unless you do believe that you have received an injury, and you would not have been in this situation had it not been for this particular workplace, for this particular company. And of course, evidence documentation is the foundation and the most important thing when putting forward a claim. And if you're outside of this time frame, outside of this bracket, in some circumstances you do have up to 3 years. In more serious cases where the impairment has been documented for a very prolonged period of time and you are still being impacted. So this is going to vary case to case, but the important thing to note here is that the common misconception is that you still need to be employed and working in the company, and you do not.